The House Judiciary Committee will come to order. Would the clerk please read in the letter from Speaker Tate?
A letter from Joe Tate, Speaker of the House, dated January 12, 2023, to Mr. Rich Brown, Clerk of the Michigan House of Representatives. Dear Mr. Clerk, I appoint the following members of the 102nd Legislature to the standing committees for the 2023-2024 legislative sessions. For the Judiciary Committee, Representative Kelly Breen, Chair. Representative Kimberly Edwards, Majority Vice Chair. Representatives Kara Hope, Jason Hoskins, Tyrone Carter, Penelope Cerniglu, Noah Arbit, Emily Devendorf, Andrew Fink, Minority Vice Chair, Pauline Wenzel, Patrick Outman, Doug Wozniak, and Gina Johnson. Sincerely, Joe Tate, Speaker of the House.
Thank you, Madam Clerk. And now will you please take the attendance?
Chair Breen.
Present.
Representatives Edwards,
Present.
Carter,
Present.
Hope. Here. Arbit,
Here.
Devendorf, Hoskins,
Here.
Cerniglu,
Here.
Fink,
Here.
Wenzel,
Here.
Wozniak,
Here.
Outman,
Here.
Johnson. Here. Madam Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Clerk. And now Representative Edwards moves to adopt Wednesday at 10:30 a.m. in room 521 of the House Office Building as the normal day, time, and location for the meetings of the House Judiciary Committee. Will the clerk please take the vote?
Chair Breen.
Yes.
Representatives Edwards,
Yes.
Carter,
Yes.
Hope,
Yes.
Arbit, Devendorf, Hoskins,
Yes.
Cerniglu,
Yes.
Fink,
Yes.
Wenzel,
Yes.
Wozniak,
Yes.
Outman,
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, 0 pass. The day, time, and location motion is adopted.
Thank you, Madam Clerk. The House Judiciary Committee will follow the uniform committee rules stated in the House standing rules that were adopted on the House floor. We will now hear a presentation from the Department of the Attorney General. We have with us today Attorney General Dana Nessel, and we welcome you and are eager for you to present to us.
Good morning, everybody. Thank you so much for having me here today. I have with me Mitch Albers, who is our Director of Legislative Affairs and Policy, and also Aaron Van Langeveld, who, what's your title? What did we decide your title was?
Senior attorney.
There we go, senior attorney, who are both going to be assisting me with policy over the next 4 years. Congratulations to all of you for being assigned to the best committee in the chamber and the most exciting committee. Don't tell the other committees that I said that, but you guys have the ability to get so many things done, and it's really exciting to be here, and I hope to have the opportunity to testify on many, many occasions about a number of different things. I think just a sort of a refresher for some people and for others who are either new to this committee, new to the legislature, that I think will be helpful as an overview of really just what the Department of Attorney General is and what it does. I think it's just important because a lot of people don't know that. We are a small but mighty state department. We have approximately 550 people who work at our department. 304 of those currently are attorneys. 57 are special agents. We have our own police force within the Department of Attorney General. Our budget is approximately $118 million annually. But what you get for that is the fact that we defend the state of Michigan. We are the lawyers for the state of Michigan. So we represent state officials like the governor and the Secretary of State, all the state agencies and most of the commissions. We also represent the state legislature from time to time upon request when the legislature is sued, and we've done that numerous times since I've been in office over the last 4 years. So we are asked on a daily basis for legal advice from our client agencies and commissions. And then again, when those agencies or commissions get sued, We are their attorneys who respond to those lawsuits and who represent them in court. We also represent the state of Michigan when your laws are challenged in court. And that's part of the reason that I want to really develop a good relationship with everyone, because I want to make sure that the laws that you pass are not overturned in the courts and remain on the books for a very long time. What you might see from time to time is something that we call a conflict wall that we put up in the office. And what that means is sometimes you'll have a conflict between agencies or commissions. Sometimes I will take a particular stand, as I'm permitted to do, in what's called my parents' patriae capacity, where we'll be defending a matter on one side, and then I will take a different position on the other side. That happened just the other day in a case you might have seen, the Mothering Justice case involving adopt and amend. On one side, we had lawyers who defended the practice of adopt and amend utilized by the legislature in 2018. I took another position that it was unconstitutional. Sadly, I think I assigned the better lawyers to the other side because they won in court, but we're coming back because that case is probably going to go to the Supreme Court, I hope. But that happens quite frequently, that we'll be on both sides of an issue with a conflict wall in between. We handle some of the biggest cases that are filed in the state, and in doing so, we save the state of Michigan, frankly, from going bankrupt every single year because we have very good attorneys, and we have lawsuits, approximately 40,000 lawsuits every year. Some of them are multi-million-dollar lawsuits. But we also bring cases proactively on behalf of the state. So, for instance, the opioid settlements that we've been engaging in, which will bring in over $1 billion to the state of Michigan. When all is said and done, I'm hoping that it's closer to $1.5 billion. Half of that will go, much of it will go directly to the municipalities, and the other half for all of you to decide how to distribute around the state. Our PFAS litigation project, where we filed over 17 cases against manufacturers and also local companies, state companies that caused contamination. We had our first settlement of the cases that we filed that we began in 2020 just the other day with Asahi Plastics, a multi-million-dollar settlement where in Livingston County, this company is now going to have to clean up the PFAS contamination that they caused at no cost to the state whatsoever. And that's sort of our motto. You made the mess, you clean it up. That's up for the company to have to pay for, and not at the taxpayer's expense. The crown jewel of our office, I'd say, is the Consumer Protection Unit that was, I think, the first in the country, started by Frank Kelly many years ago. We field thousands and thousands of complaints from consumers every single year when consumers are ripped off, when they are taken advantage of, when they fall for a scam. That's the place to report it. We go after the bad actors anytime we can. We've recovered over $50 million to consumers that were ripped off since I've taken office. We also have some of our new initiatives that are housed within that particular unit. We have our anti-robocalling unit, where we have been more aggressive when it comes to going after some of these robocalling shops. We've been more aggressive than anybody in the country, except for maybe Ohio we're tied with, I would say. So if you've noticed a considerable, fewer number of robocalls since 2019, you're welcome. But it's been incredibly effective, the work that we've done, and we're looking to continue to do that work. We also established something called MITS, the Michigan Identity Theft Support System. And this is something important for your constituents to know about, because when you have a constituent who has fallen for some sort of scam and their identity has been stolen, this is the place to report it. And it's not just that we try to assist you in going after whoever the bad actor is. We help to restore that individual's identity. And we do that through our identity theft support system. And this is something important for your constituents to know about, because when you have a constituent who has fallen for some sort of scam and their identity has been stolen, this is the place to report it. And it's not just that we try to assist you in going after whoever the bad actor is. We help to restore that individual's identity. we assign them a caseworker, and we go step by step by step to try to assist them. So please, if you have constituents that are getting robocalls or who have identity theft issues, that's not going to be something that a local prosecutor can help you with. You come to our office for that, and we will be of assistance. In terms of criminal activity, we handle cases that really the 83 county prosecutors' offices are just not equipped to handle. And so we have many, many specially assigned units where the AG's office is the place to go for those kinds of issues. We have our healthcare fraud unit that handles Medicare and Medicaid fraud cases. We also oversee activities that occur in nursing homes. So I created something a few years ago called the Sentinel Project. If you have a constituent who has perhaps a loved one who you feel like they're not being treated properly in a nursing home, that's the place to call us. We do surprise inspections in the Sentinel Project. Our goal isn't necessarily to shut down nursing homes. Our goal is to make them better and more responsive. So we do a number of those unannounced visits, and we've been ramping that project up recently as well. And when you see criminal cases that come out of nursing homes, those are from our department. We also have a financial crimes unit. These are large-scale financial crimes, Ponzi schemes, major embezzlement cases, cases that involve misappropriations of funds from state government. We handle treasury cases there, so tax fraud. We also have our elder abuse task force that is housed within our financial crimes unit. And so some of you, I hope, will sit on that committee. We have, bipartisan, both chambers, over 50 senior advocacy organizations that we work with, over 100 people that are on the task force, and we'll be coming to you time and time again with suggestions of laws that can better protect seniors and other vulnerable adults in the state. We also handle child support cases for much of the state as well, and we recover millions and millions of dollars in child support from parents who are not properly paying their court-ordered child support. And we also regularly go after bad guardians and conservators when they abuse their offices and take advantage of vulnerable individuals and protected people. We have a special litigation division where we work to protect ratepayers, and we routinely intervene in utility cases, and we work with consumer advocacy groups, and we present testimony, we cross-examine the utility companies, and we try to hold the utility companies' feet to the fire every time they ask for a rate increase to ensure that that rate increase is really appropriate. And over the course of the last 2 years alone, we have saved ratepayers $1.3 billion from our challenges to them. Our criminal trials and appeals unit. So I am technically by statute the top law enforcement officer in the state, but don't tell Kim Worthy that because she thinks that I still work for her. But we handle a variety of different types of cases. Again, it's geared towards the types of cases that the county prosecutors cannot handle. They don't have the resources, they don't have the staffing, and oftentimes not the expertise. So we handle, for instance, all the appellate cases for the 56 counties that have 75,000 people or fewer. So we handle all their appellate cases when their trial cases get appealed through the Court of Appeals and the Supreme Court. We do all the habeas corpus petitions for state prisoners. We handle large-scale multi-jurisdictional cases, such as you're probably familiar with our clergy abuse investigation spanned over the course of 7 dioceses around the state. The Boy Scouts of America investigation, over 3,000 purported victims there. The Nassar, Michigan State University investigation. Human Trafficking Commission is housed within our department. Also, we handle a lot of cold case homicides, and I'm really proud of the fact that we just solved and charged a couple of very old cases. SPAs, what are those? Special prosecutor assignment cases. So what happens is all the county prosecutors, when they have a conflict of interest in their case, in a case, for instance, maybe the prosecutor knows somebody involved in the case could be a victim or a defendant or a witness or something, or many other kinds of conflicts, they send those cases to us. And we can either keep the case and handle it within the Department of Attorney General, or we can send it out and try to find another county that will handle that case. And so we get those every single day from prosecutors around the state. We also have a public integrity unit where we handle cases against police officers on officer-involved shootings and in-custody deaths, or other public officials. Some of the cases you're probably familiar with, the Eric Smith case. We prosecuted the clerk from Southfield and the former clerk from Flint. We have some pretty big ongoing investigations that I know you guys are aware of. The fraudulent signature case with the 5 gubernatorial candidates, Unlocked Michigan case involved former Speaker Chatfield. So some really cases of great significance that are very time-consuming, require a lot of resources, not something that county prosecutors can typically do, and are usually multi-jurisdictional. We created, in 2019, I created an auto insurance fraud unit. We partner with DIFS with that, so we are really the only ones. There's not some other county prosecutor that prosecutes those types of cases. Also created a hate crimes and domestic terrorism unit. And what we do there is not just to prosecute people where there's animus-related crimes, but also large-scale cases that involve, groups like the Wolverine Watchmen. We prosecuted the Base. They're a white supremacy group that had designs on large-scale carnage. We handle threats against public officials, including the legislature. So in the event that you were to receive a threat, and I know there's a process involving the sergeant at arms, but we do take those cases and we have special expertise. And why we don't always advertise it, I mean, these are cases that involve both Democratic and Republican members of the legislature, and we've handled many, many cases, successfully. And I urge you that if you do have something like that happen, that you make sure that our office knows about it so we can assist you with that. Some things that we've partnered with the legislature on and that are up and running just now, the Organized Retail Crime Unit, one of the first in the country, over $1 billion in losses to chain stores, to small businesses across the state. They're multi-jurisdictional and racketeering cases. Our Job Corps program that we are getting up and running is a pilot program in 3 counties, Wayne, Genesee, and Marquette. And these are individuals who will be going to a special diversion program where they're diverted from the criminal justice system into job training and directly into a job with an employer. And if they're able to keep that job for a year, then their case, which is our low-level non-assaultive cases, can be dismissed. So that's something we're working on. It's also where we have a conviction integrity unit. So if someone claims to be wrongfully convicted, they can fill out an application for our office. We investigate and oftentimes get individuals exonerated where there is clear evidence that that person is actually innocent of the crime of which they've been convicted. We also have we handle all the WICA claims, the Wrongful Imprisonment Compensation Act, that gets funded through the legislature. And where you have somebody who has been found to be wrongfully convicted and they've been exonerated, they can make a claim for, it's $50,000 a year, right? Yeah, for every year that they spent in prison. We also have, that's where we handle all the expungements. After it goes to the Michigan State Police, it comes to us for the department to issue a letter indicating whether or not a person is eligible. We processed over 14,000 applications last year, and a lot of it was in part because of the work that many of you did on the clean slate package that allowed for more people to get expungements. And we also do fairs all over the state. So if any of you are interested in us having an expungement fair in your district, please let us know. We're happy to come out to your district and host one of those fairs. We also house the address confidentiality unit. For those of you who've been around for a few terms, you helped to pass that. It's so victims of domestic violence and other assaultive crimes don't have to have their address listed publicly, and they can do it through the state. And we manage that. The law takes effect on October the 1st. I wanted to talk for a minute about AG opinions, which I'm sure you've heard a lot about. Who can ask for these? It's limited. I don't think that a lot of people know that. You have to be either, a state officer, one of our client agencies, or a member of the legislature. And you can send us an AG opinion for us to take a look at a particular issue. And when we issue a formal opinion, it's binding on state agencies, but just know it's not binding on the courts. So it can be used certainly in pleadings, and a court of law can take our opinion into consideration, but they don't always hold up in the courts, and it's not mandated that they do so. Sometimes, what we ask you to do is to contact either Mitch or Aaron and say, hey, I have an issue that I'd like to explore for an AG opinion. And sometimes what's best is for us to analyze it, get back to you, and tell you whether or not we think it's best that but it's best situated for an actual formal opinion, or maybe just an informal legal advice. I know you have your own attorneys, but obviously we have a lot of subject matter experts in our department, and so we welcome that dialogue. Just wanted to go over some of the priorities that we're probably going to have involving your committee. The Michigan Consumer Protection Act once was considered one of the most powerful ways to protect consumers in the state, and really one of the best laws in the country. Kind of gutted from some court decisions back in the 1990s. We actually filed a lawsuit against Eli Lilly based on really price gouging for insulin, but the problem is that there was an interpretation during the 1990s that it only applied to unregulated industries, which we don't agree with that interpretation, but we're going to be asking for a specific change. This law has been neutered in Michigan, and we have the ability to do so much more to protect consumers like they do in states all around the country, things that we can't do because of that current interpretation, but you guys have the ability to change that. And so we are going to be asking for that, along with some other aspects of the Consumer Protection Act that we can really beef up to help people around the state. Our Elder Abuse Task Force guardianship reform legislation, some of you have seen that before. It won't be the first time you've seen it. We're hoping to get it across the finish line, and we have a lot more legislation that we think is going to come out of that task force. Very, very important work. We have some police improvement proposals. All of our proposals, I should say, we came to working in concert with the Michigan State Police. So our proposals, we worked with them shortly after the George Floyd murder in 2020, and that's when we released these. I testified in the Senate in regard to it. We haven't really made any progress, but some of these are just some really common sense reforms that I'm really hoping to get bipartisan consensus on. Creating a statute allowing pattern and practice review by the Department of Attorney General. Many AG's offices have that, but we don't. And that would allow us to go into whether it would be to go into a police department to see if there are issues where they're routinely violating the constitutional rights of community members, whether it has to do with another agency. Those are the types of things that we find to be very helpful in assessing whether a department is operating properly, but we don't have the authority to do it. People ask us all the time, and it's just not something that we're permitted to do. Human trafficking legislation, again, it's been proposed, I think, a few times to help support survivors of human trafficking and for better accountability for perpetrators. We have lots of robocall legislation that we're hoping you'll take a look at. I hope we can all together get behind fewer robocalls, very, very bipartisan, nonpartisan issue. I don't know who the pro-robocall lobby is, but I guess we'll find out. Data breach protection legislation, data privacy, regulation of data brokers. You're going to see some legislation coming up from us on that. Expungement issues. Many of you worked really hard on the clean slate legislation, but like everything, sometimes you need some tweaks, and there are things that are just not working the way we think the legislature intended it to work, and probably need a few adjustments, so we'll be coming to you with that. The Government Imposter and Deceptive Advertisements Act, it's when you have entities that offer paid services for things that the state already provides. Witness and victim privacy legislation. We brought this up last term, has to do with making sure that victim and witnesses' personal information is kept personal and private, and unless ordered by a court, is not turned over to the defendant and to defense counsel unless there is a legitimate legal reason for it. Open Meetings Act and and FOIA. There's a lot of changes. These are laws that were passed in the 1970s. They don't properly reflect modern technology, and they really need some updates. Updating the criminal enterprise statute to include tax fraud and financial exploitation of a vulnerable adult. We could be doing so much more in so many different areas if we had additional tools, and under our CCE statute that allows us to go after criminal enterprises, we really need better predicate offenses for that. So that's the basics. I will tell you that, firstly, the thing that we all have in common, no matter which side of the room you're sitting on, your constituents are my constituents. And I want to make sure that our department is there and available for everybody whenever you have an issue, whenever you have a problem. Please don't hesitate to reach out. Again, we do have some incredible subject matter experts, and we want to make sure that your legislation actually accomplishes what you want it to. And then again, it withstands judicial scrutiny in the courts. And so we're here to help. Please tap us up, ask us for any kind of advice that we can possibly provide that will help you do your jobs the best that you can do it. We're here to help. So, what did I miss, Mitch? Anything? Did I get through a lot? I talked for a really long time, didn't I? Okay.
No.
All right.
Thank you, Attorney General Dana Nessel. You preempted some of my questions, particularly when it comes to getting an opinion from your office. I would encourage everybody up here, if you do have a question. Her office has been absolutely invaluable to me over the years. You are flanked by two excellent attorneys, which is wonderful to see. I have a question. Did you say it was the robocall area or the consumer protection area that Ohio was just as good at?
We're sort of like in competition with Ohio. They have a really strong anti-robocalling game, and in fact, the only two national summits that were held on robocalls that involved, FTC, FCC, and groups from all over the country were joint between Ohio and Michigan. A.G. Yost is a Buckeye, though. It's very hard to be around him except the last couple years.
Well, I was going to say, I find it extremely odd you would let Ohio get the leg up you on anything at all. So.
Well, funny that you mentioned that, but Ohio's consumer protection unit has about twice the staff that we do. So just something to remember for any of you who sit on appropriations as well is, we want to beat Ohio in every single way there possibly is to beat them. And that includes how aggressive we can be in terms of going after robocalls and what we can do to protect consumers all over the state.
I believe your office, at least a couple of years ago, you had a sheet built out as far as consumer issues on many different areas, arenas that people could call if they have any issues from, a bad car sale or any type of product. Does your office still have that available?
We do, and what we'd like to do is get that to all of your offices. We have little cards, and it gives you all the information on, the email address, phone numbers, and how to get a hold of us in a variety of different subject matter. So we'd like to get that to everybody in that way. If somebody calls your office and says, hey, my mom just clicked on this link, and, we'll be able to, immediately help after you have somebody contact our office, and we get back to everybody.
Well, thank you for that, because I know that our office has found that very helpful. I believe all the other offices will too. When you get a call from one of your constituents and they have a complaint about something, there is a very good chance that the Attorney General's robust list from the Consumer Protection Unit will have a contact for you that you can refer your constituent to. And I hope it's relieving for you to know that I know things are already in the works regarding the Consumer Protection Act, guardianship bills, human trafficking, and I look forward to working with your office, and I'm sure we all do, to get some of these initiatives through. We do have quite a few questions, and I'm going to go in the order that they came into me. So, Representative Fink.
Thank you, Madam Chair, and Madam Attorney General, thanks for being here and bringing your staff. It's good to see everybody. And I want to first just say I appreciate that you focused a bit on the day-to-day ways in which constituents that we have and share with you can interact with your department, the consumer protection services that you provide now, the child support issues, the fiduciaries, guardians, conservators, whatever. So I do think that sometimes folks forget how much of the work of the government that we do is sort of relatively mundane from the public's perspective, but very important to individual constituents. So I appreciate you highlighting that this morning. I did want to ask a question. I have a second question, but understanding Chair Breen's list is long, I'll save the second one for another day, but unless she gets back to me, which I doubt. But on the Consumer Protection Act issue, my understanding, it's been a while since I've read the case law on it, so I might be remembering it incorrectly, but my recollection is that the reason that licensed or regulated industries aren't interpreted currently to fit into the Consumer Protection Act scheme is because if you both have a gatekeeping function at the state level of licensing or regulating sort of entry into a market, and the same entity is subject to Consumer Protection Act litigation and the attorney fees and essentially the incentive to litigate over it, then you're kind of catching those industries coming and going. And so my question would be, if you think it's appropriate to expand the Consumer Protection Act, or perhaps clarify, at least from your perspective, clarify that licensed industries or regulated industries should also be subject to Consumer Protection Act liability, do you think that there would be a reason to look at some reform on the front end regulation of those industries on the licensing side, or some other aspects of the way in which the state regulates them? Because the Consumer Protection Act is essentially the oldest form of regulation, which is tort liability. And by leaving industries there rather than regulating them, you allow the consumer to be essentially his or her own regulator. And if we're going to subject industries to both that conventional tort liability with the sort of added reasons to litigate under the Consumer Protection Act, would it be appropriate, in your view, as I guess it's clear it would be in mine, to look at whether the barriers to entry that the state currently has should be relaxed in some way?
Well, I'm gonna let Mitch take a lot of that, but I will say that the Consumer Protection Act does have a number of different areas in which you specifically cannot utilize it, and that is insurance, and there's a number of them that are carved out that we know for a fact are not covered under the Consumer Protection Act, and that you have those regulatory agencies that are charged with overseeing that. But
yeah, so I think when you look at it from a twofold perspective, like you're mentioning, the licensing and especially the licensing burden looks at folks entering the market and making sure they're meeting the requirements. But if they start then, if they are able to qualify for a license, but then start, instituting, bad business practices, we want to be able to make sure that there are an ability from the Michigan Consumer Protection side to take action when they are not living up to their abilities beyond just a licensing situation, because there needs to be a rectifying mechanism for individuals who have been, face those bad business practices, whether that's a solar company that's maybe done shoddy work, or another sort of building trade that's done bad work. You want to be able to go after and make sure there's restitution for both the individual and also a penalty, so they are either don't treat it as a cost of doing business to the state, and making sure that those protections are there when they're there. And there are built-in already exemptions, especially for heavily regulated entities like the banking industry, the credit union industry, insurance, and there are a couple others in there as well. The telecoms industry, I believe, is also in there, where those limitations already exist in the statute. And I think, we'd be willing to have conversations about, what broadening out the Consumer Protection Act looks like. But we do know that there have been a significant number of cases where we have been limited to take action that our neighboring states have been able to provide those relief to the consumers that have been harmed by those companies. And we think we should be able to provide that same opportunity to our consumers in Michigan.
And I really look forward to the opportunity to bring in either AGs, current AGs, or former AGs from other states so they can sort of spell out how their Consumer Protection Acts work. And these are red states and blue states. And just to see really the difference in terms of the protections that are provided under their laws versus our laws, and why we really need to strengthen our law.
Very quick follow-up. So, is the main thrust of the reform that you think you're looking for this term directed at the action that the Attorney General, the Department of the Attorney General, is able to take under the Consumer Protection Act, rather than increasing the ability of consumers themselves to litigate under the MCPA? Okay, thank you.
Yeah, that's correct.
Okay, thank you.
Yeah, we are looking to add authority to the Department of Attorney General in this practice, not so much maybe in the private right of action side.
We have a few more questions. I'm going to ask my colleagues keep them brief because we have Judge Boyd on tap. And I know we're supposed to have Justice Kyra Bolden here today, but she unfortunately had a family conflict. And just noting that, I'm going to move on to Representative Carter.
Thank you, Madam Chair. Thank you, Attorney General Nessel, for being here today. First, I'll give you a shout out. My identity was stolen across state, county lines. So, being a former law enforcement, I did my own investigation and found out where to take it to. And I'll say that I'm happy with the outcome. There was a conviction. And so we're going to do a victim impact statement next month. But for the ordinary person, you may have touched on this, can you give me some information to my office that I can get out to everyday people for the everyday scams? Because they may not know a starting point or who to go to. And when you call the local police sometimes, they get to run around and get frustrated. And many of these crimes, whether it's with the gift cards to pay off through Bitcoin or anything else, don't get reported, number one, because they don't know where to go, and number two, sometimes it's embarrassing. So any guidance that you could offer to, and I'm a senior myself, so the seniors that are a little bit older than me that are really, more likely to be scammed. So I'd appreciate that.
Yeah, absolutely, we'll do that. The other thing is that we offer, I do senior scam presentations, consumer protection presentations. I go all over the state and do them, and I find that they can be really helpful because the thing is, as much as once you have fallen victim to a scam or one of your constituents has, we can do everything in our power to go after that bad actor, to try to get indemnification, to try to get your identity restored. But honestly, the best thing that we can do is educate people on how not to fall victims to scams in the first place. And all scams have really common themes, even though they change over time and they're sort of topical depending on what's going on in the world. They all have the same basic characteristics. And so we like to train people on that. We put out videos on that you can send out to folks. And certainly we want to make sure that all of you have the information to give to all of your constituents so that they know where to go immediately. And for those types of things, it really is best just to come right to our office because, again, a local police department on an identity theft issue like that may not be able to help.
Just quickly, we all have newsletters, so when we get our footing, I'd appreciate if you'd send me something, and that way I can send it out. Thank you.
We will.
Thank you. Representative Edwards?
Thank you, Madam Chair. I do have a couple of questions. You indicated information regarding the job court. I wasn't able to capture all the information because it kind of went by really fast. So
Sure.
could you elaborate on that?
Yeah, it's a pilot program that we put together last year, and I think was included in the budget for 3 counties for a pilot program. And essentially, we needed county prosecutors that were interested in the program and that would cooperate with us. But it's a diversion program where individuals who have been charged with non-assaultive, low-level crimes, and each of the prosecutors in those counties, they get to make the determination as to who enters the program. But we partner with local employers who have signed up for this program. And essentially what we do is the individuals are placed into the program. They're provided with wraparound services, and they're given a caseworker who manages them. And that way, for people who have, barriers oftentimes to maintaining employment, which often leads to crime, whether it's transportation or child care or sometimes it's, housing-related issues. Sometimes it's substance abuse-related issues, and they need assistance with that. We provide the wraparound services, partnering with local agencies, and we try our hardest to ensure that person is going to stay in that job, with the theory that if you've gone to work, if you get a sign-off from your employer that for a year you've maintained steady employment, that we dismiss that case in exchange with the understanding that it's much less likely that you're going to reoffend if you have a job, and these are jobs that, have they're good paying jobs, they come with full benefits, and the hope is that once you've maintained that job for a year, you're not going to re-enter the criminal justice system. And also it helps with local employers who, as you know, are really struggling right now to find employees. So we have more employers than we know what to do with in terms of those that want to participate. But that program is going to be up and running. It's already sort of started in Genesee. Marquette is probably next, and then Wayne County may take a little bit longer. But in the next couple months, I would say it's going to be up and running in all 3 counties. And I would urge you, we're going to keep stats on everything, but if you are in a county that I did not list and it's something that you might like for your county, please let us know, because we want to expand this program. We think it's going to be wildly successful. As far as I know, it's the first one in the country of its kind.
Thank you. We're going to take one more question from Representative Outman and then let you go free so we can hear from Judge Boyd.
Well, thank you, Madam Chair, and thank you, Madam Attorney General, for being here. You mentioned one thing that did perk my interest, and that was witness information reform. Could you expand on that, and what is the current practice with that?
So there was a case that came out of Ingham County last year, the year before? Last year. And I think that was a murder case, right? Anyway, there was a ruling that was it was unusual to me in the case, and it basically the ruling was that the witness information and the victim's information had to be turned over during the process of discovery. And when I say information, I mean their address, their telephone number, other types of personal information. Now, I've practiced criminal law in this state, for a really long time. For 29 years. And that was never the practice before. Generally speaking, that information would be redacted when it was transferred from either the police department or from the prosecutor's office to defense counsel. And if you needed it, if it was an important, essential part of the case, let's say there's information about phone calls that is part of the testimony, part of the evidence, and you need to know what that witness's phone number is or that victim's phone number is, obviously it would be turned over because it was a necessary component of the case. But unless that was the case, generally speaking, that was not automatically turned over, and this case sort of flipped that on its head. There was some debate about what the court rules allowed for or didn't allow for, but to me, I think, victims and witnesses already are scared to come forward. And we have just significant underreporting of all kinds of crimes, especially assaultive crimes in our state, rape cases, other kinds of assaultive cases. And we have witnesses that don't want to cooperate because they're so fearful that there'll be some sort of retaliation. And so to me, the last thing we should be doing is just, as a matter of course, automatically having the entity that you're supposed to go to because you trust, law enforcement, turning over your personal information to somebody who could be charged with a really serious crime against you. And so that's the Ricky Jack case. We had legislation that was proposed last term. I know, I think Rep. Filler and Senator Victory, I think were, Yancey, yes, and Rep. Yancey were sponsors on it. Unfortunately, it just, where did it go? Did it pass at all?
Didn't pass the Senate.
It didn't pass the Senate. So we're going to try it again this term. I just, if we're not going to protect personal information for witnesses and victims of crime, I think that the system is really broken. And I think we need to do more to protect victims in this state.
Yeah, it sounds like that could be extremely dangerous. So, and I'm sure there's a balancing act there, but I look forward to looking into that issue a little more. So, thank you for that answer.
Thank you.
Thank you, everybody up there. We look forward to a lot of good work in the coming term, and I'm sure we're going to be seeing you here plenty. So thank you again. Next up, we have a
so much.
presentation from Tom Boyd with the Supreme Court Administrative Office, otherwise known as SCAO. Welcome, Judge Boyd. Just so the committee knows, we're going to have a hard stop at 11:45, as there is another meeting in the room after this. While the judge is getting set up, I know that many of my colleagues on the Democratic side were also in criminal justice yesterday, and we talked briefly about trial court funding. There is a commission report. I'm going to encourage everybody to look at this. We're going to have to work fast to ensure that our courts have the funds and resources that they need to keep running smoothly. Definitely a lot of changes have been recommendations. I think we all have some room to dig our heels into this. And for those that were here at criminal justice yesterday, some of this might be redundant, but also there, again, is plenty of work to go around. So I know that Representative Hope and I are going to be joined at the hip as we chair our respective committees, and everybody at this table is going to be part of the good work ahead. So thank you, Judge Boyd.
Thank you. Good morning. Good morning, representatives. And we saw the significant overlap between the two committees, so the presentations are different. I tried my best to split civil criminal, but after talking with both chairs, I know that the line will be very fluid, and we're, of course, comfortable with that. I think it's great following the Attorney General. Actually, I'm pretty sure this month is my 28th anniversary as a state employee when I became an Assistant Attorney General under Frank Kelly in February of '95. I think that's right, somewhere in there. It's a long time ago. So it's great to follow the Attorney General. I'd like to just begin with the constitutional framework. This is, we talked about this yesterday as well, but the constitutional framework in Article 6, Section 1 of the Constitution from 1963, it makes it clear that the judicial power in the state is put in one court of justice led by the Michigan Supreme Court. So the judicial branch is a separate co-equal branch of government. And in this committee, you'll see sometimes how those two things interact, that coincidence. It's very clear, Article 3 talks about the fact that the Supreme Court can hire an administrator and as many assistants as necessary to aid in the administration of justice. So this is just to make the point that SCAO is not an independent thing. It is the staff of the Michigan Supreme Court. The legislature often will put in the statute, at the direction of the Michigan Supreme Court, SCAO may or shall, on and on. But we really are the staff of the Michigan Supreme Court. The court has two functions, really. It decides cases, which is what you read about in the paper, but it also has the administrative responsibility for all of the court system in the entire state. In Article 6, Section 4, it talks about the fact that the court has superintending control over every case everywhere. In its rulemaking capacity, Article 6, Section 5 talks about the fact that the court has the authority to establish, modify, amend, and simplify the practice and procedures of the court. Now, the reason I put this slide in here is because in this committee, you will have people who propose things to you, and I'm going to come and say, well, wait a minute, is that substantive law or is it procedural law? Because the legislature creates substantive law, the law that affects substantive rights of people coming before the court, but the Supreme Court has the right to set procedural law, how the courts work. And sometimes those are complicated issues where that line is. There's many Supreme Court cases talking about where that line is, and I'm certain in this committee we will talk about where that line is over the next couple of years. This is just emphasizing the point that we work for the Supreme Court. It literally says in the Constitution they can fire me anytime they want to. Isn't that nice? As it looks at the staff of the Supreme Court, again, referring back to Section 3, I just want to emphasize, and this presentation has also been made available to each of you, so if you need to see it again to refresh. So on the left side of the chart, you're talking about the people who work in the case decision-making part of the court's function. The clerk's office, the commissioner's office, the reporter's office. Those are people who work on the cases that you see the Supreme Court made a decision. General counsel's office is just that, the Office of General Counsel. As a matter of fact, we are currently have a vacancy in the General Counsel. Our phenomenal General Counsel, Cammie Pendle, has moved on to other challenges. We greatly miss her, and we hope we'll have somebody replacing her very soon. And that person will be a primary liaison and supervise the work between not only the judicial branch and the legislative branch, but the judicial branch and the executive branch. Over on the far right side, you have the State Court Administrator's Office. And that's where the bulk of the work that the Supreme Court has in terms of the trial court system takes place. I suspect that depending on the issue, we will come in and talk in great length about some of those boxes. But today, I just want to make sure you have it out there. This is available on our public webpage. This document is just a picture from our public website. These are the general principles that guide us in our work in terms of the administration of justice. The court system's complicated. In 1963, the people, through enacting the Constitution, ratifying the Constitution, declared one court of justice, as I've just mentioned, but they didn't pay the bill. And so what we have is a non-unified court system paid for by by counties, cities, townships, and it results in things like this: 20 different case management systems, 242 different trial courts, 150 different computer systems, 559 different trial court judges, and 83 elected county clerks that serve as the clerk of the county circuit court by constitutional mandate. That's in the Constitution. Our goal in all of this is to have an innovative, transparent, and efficient justice system that works for everyone. Now, the next things I'm going to talk about are different than we talked about yesterday, because, again, the Supreme Court in the last few years, under the leadership of Chief Justice Bridget Mary McCormick and now under Chief Justice Elizabeth Clement, are changing the way that things are done within the judicial branch, and that is to be more inclusive and to not have strategic planning done by staff in a pretty building down the block, but by a group of stakeholders. So the creation of the Michigan Judicial Council is exactly that: how to develop a strategic agenda for going forward as a judicial branch. And that's the one-page document that you have in front of you. It talks about the mission, values, and vision created by the Judicial Council to guide the judicial branch. The Judicial Council was created by administrative order, and it has a very broad base of people in terms of judges from district, circuit, and probate, in terms of practitioners, clerks, members of the public, people who service the court in non-judicial roles like interpreters. It's a very large group. It only includes 2 of the justices, and this is the group that came up with the strategic agenda. The strategic agenda is available on our webpage. That's the document on the right side. I've brought you the snapshot, which is the one page here. So you can see that we have 5 major goals for the 5 to 6 year life of the strategic agenda, but they're spelled out in 8 short-term goals that we're trying to accomplish in the next 12 to 18 months. Again, I suspect some of those will bring us back, and we'll talk about those, or I'd be happy to come to any one of your offices and talk in depth about any one of those goals. The Justice for All Commission actually came before the Judicial Council. This is really the court's first foray into group decision-making. Many state court systems do have an Access to Justice Commission. Michigan is kind of at the tail end of this, but it's a way to say, what is it we need to do to provide access to the court system for people who need their civil justice problems resolved? In a lot of ways, the question to ask, to enter into this discussion is the court a place or a service? And depending on how you answer that question, you're going to process all the other questions very differently. So if you see the court as a service, the way I do, a place where people can come and get their civil justice problems resolved, whether that's on a computer from home or whether they're physically in a courthouse, you look at ways to increase access to justice. If we are a service, we have lost market share in the last 20 years in tremendous ways. The eBay dispute resolution program resolves more disputes than the Michigan court system, right? So what is it we're doing to provide the service the judiciary was intended to, help people resolve their civil justice problems, and what can we do better? That's really what the Justice for All Commission is about. And in pursuing this, again, a broad base of stakeholders on the commission, but we've been able to, just in the first year and a half of the commission's existence, provide a much deeper dive at some of the data that we have available to us. One of the reports that I've highlighted here in this slide talks about the fact that the Justice for All Commission, we've been able to quantify for every dollar invested by the state in legal services, $6.69 is brought back in positive economic activity, almost sevenfold return on investment in terms of social impact from every dollar that the legislature puts into legal services or that the community writ large puts into legal services. This is the kind of data we really didn't have access to before working with the Justice for All Commission. And when I say that, I mean not only the money that the legislature appropriates to that effort, but we have partnerships with the Pew Charitable Trusts, and they retain data experts, including a firm named January Advisors that helped us look into the data in this area. We have reports on small collections cases. I knew, as a district court judge for 14 years, the names of plaintiffs in collection cases I saw routinely. I didn't realize that those same names were in every court. In fact, January Advisors has showed us that 5 plaintiffs file more than half the cases in Michigan on collections, credit card, health care, small collections. And so we've been able to look at that data, and we're going to be able to provide better services to both those plaintiffs and to defendants by understanding who they are and what they're trying to do. We have January Advisors look deep into the landlord-tenant data, looking at what is actually happening in landlord-tenant prior to the pandemic, during the pandemic, and today. The problem in many of these cases is the defendant doesn't know they have a chance, doesn't believe they have a chance, so they just don't show up. So our default rate, meaning the defendant never appeared, in these cases is huge. And if our goal is to resolve civil justice problems, two sides not showing up in a case is not meeting that goal. And so what is it we can do to try and enhance a just result based on interaction between the parties, as opposed to sort of just being the rubber stamp for the one side that knows how to do this? Something like 83% of people in a National Center survey say they cannot afford a lawyer to resolve their civil justice problems. So we need to look at different ways to do that. So one of the work groups in the Justice for All Commission is on regulatory reform. Are there ways to provide legal services with something less than a full-fledged JD member of the bar? Are there ways to fill that gap for people who can afford less than perhaps a full lawyer? That work group is, I would not call them cutting edge, but there's only 3 or 4 states out there trying, and the work group is trying to figure out how Michigan fits in that. I should note that both the work group and the commission as a whole are chaired by Justice Brian Zara in terms of all the work to create all this. The Commission on Diversity, Equity, and Inclusion recently had its first in-person meeting where they have, as an initial matter, hired a facilitator to work with the commission members to see what it means to really tackle diversity and equity and inclusion in a meaningful way for the entire judicial branch. This commission created by administrative action of the court. Yesterday at criminal law, I talked about entities created by statute, created by executive order. These here in the civil arena are created by the Supreme Court through its administrative authority. Again, I've given you, so when you have the slides, all the names of the people involved in each one of these entities, at least originally. The Justice for All Commission is now mature enough that we have had some turnover. Finally, the newest, not finally, I'm going to talk about trial court funding next, but the newest group is on well-being in the law. This is a partnership between the Supreme Court and the State Bar of Michigan, led by Justice Megan Kavanaugh, to look at what we can do to enhance well-being of all of those people that participate in providing judicial branch services, whether they are judges or lawyers or staff. what it is we need to do to make sure that people who are in these high-stress environments are taking care of themselves. And that's a brand-new initiative. That's the names of the original membership. Again, you can see broad-based, trying to make sure that every voice is heard. I'm going to go to the Trial Court Funding Commission, and as Chair Breen indicated, I put the entire report from the commission on your desk. In short, the question of how to fund the courts has been an issue in Michigan for quite a long time. At the Constitutional Convention in 1962, the question of the role money plays in the entry-level court system was a real issue. And it's the reason that the 63 Constitution abolished the Justice of the Peace system, the Circuit Court Commissioner, and a couple other positions, and ordered the legislature to create courts of limited jurisdiction, which eventually became the district courts in 68. But already by 82, there's a Court of Appeals opinion where the Saginaw libraries sue the judges of the Saginaw District Court, asking where the fines used to go. I skipped a step. Every constitution in Michigan since 1835 has said that all penal fines go to the local library. In 1835, there were not a lot of people living a lot of places in Michigan, but they were convinced of two things. One is if you leave money in the criminal justice system, it will corrupt that system. And two is people who commit crimes probably need education, so they stop committing crimes. And that line has been consistent throughout our constitutional history. So in 63, what they're trying to do is to return to that. And in documentation from the Michigan Municipal League campaigning for ratification of the 63 Constitution, they point out this improvement in the way that money is going to be kept separate from the judicial system. Already by 82, the libraries in Saginaw sue saying they've created something called court costs, and they're taking all our fines. And the court says, you're not promised any level of fine, just all the fine. And of course, they're not charging court costs because that's not a thing. Well, of course, we all know they were. As a matter of fact, in the 2000s, the Court of Appeals was wrestling with how to properly assess court fines. There's two cases from Berrien County called Saunders 1 and 2, where they're trying to assess how do we assess court fines. Well, in 2013, I think it was, the Michigan Supreme Court in People versus Cunningham said there's no such thing as court fines. The legislature, then, honestly, I think I testified in this room when I was a district court judge, the legislature then allowed for court fines, but put a sunset on it. That sunset has been extended 3 times, and it currently is set to expire the summer of 2024. So whether it's this committee or the Criminal Justice Committee, we really need to work together to make progress on the way that the trial courts are funded. This report lays out 5 recommendations. 4 of them are substantive recommendations that are right there. And the last is like an implementation recommendation about how to go about this. So what I'm hoping, and I'm looking to work with any one of you, all of you, especially you, Madam Chair, is to find a way to put into legislation in the next 17 months, 16 months, a path forward. We're not going to resolve some of these really huge issues in that period of time, but we need to put a path forward in place, or we're just going to continue to kick that can down the road year after year after year. So that's my hope for this area. I want to touch real quickly on just 3 initiatives that we'll talk more about going forward. First is problem-solving courts, and I know Justice Bolden was heartbroken she couldn't be here with you, and she will come back and she'll talk about problem-solving courts. In the slideshow, we talked just a little bit about what that means and how it relates to what we do at SCAO. Also, the legislature in the last session made a substantial investment in our effort to move towards a statewide unified case management system. We'll be asking your appropriation colleagues for an additional investment in the operation of that system going forward. And finally, I wanted to just talk about the Judicial Resources Report. I suspect it will be this committee that communities come to and say they need another judge. And when they do that, we'll come in and explain to you the science we use to determine what the appropriate level of judicial and quasi-judicial, magistrates and hearings officer, resources are appropriate in any given court. So I'd be happy to answer any questions.
Thank you, Judge Boyd. Fascinating about the social investment in return, and also as a licensed attorney, but currently not practicing one, I'm happy to hear about the Wellness Committee or Wellness Initiative for Attorneys, because I got to say, Oddly, being a state representative is less stressful than being a practicing attorney for me. We're going to have, just so the members know, a separate presentation on the problem-solving courts. That is something that is very in-depth. There are multiple types of problem-solving courts. We have a lot of people who are new to the Judiciary Committee who aren't practicing attorneys. These are highly effective courts. They are also highly time-consuming, and that plays right into, again, trial court funding. So one of the things I do want to ask you about is, and then we're going to move on to Representative Fink's question, regarding the statewide judicial case management system, as we do not have a unified court system, which is leads to a very large patchwork across the state between district courts, federal courts, the circuit courts. What stage of implementation are we in with the case management system? Can you briefly tell us what is next?
Absolutely. So the legislature appropriated and made available to us October 1st $150 million to migrate all of the existing data in non-state systems into the state system or into a single system. First thing we did is retain the National Center for State Courts to determine whether or not the existing state system was the system to be the foundation of the future, or whether it needed to be replaced now, because the time to make that decision is now. The final report from the National Center won't be available till the beginning of March, but at this point, all indications are go that we will be expanding the current system. The system, which is JIS, the Justice Information System, which is a part of the State Court Administrative Office, currently has about 80% of the courts. We don't have 80% of the cases because we don't have 9 of the top 10 populous counties circuit courts. So right now, Wayne, Oakland-Macomb, Washtenaw, Ingham, Kent, Kalamazoo, Berrien, Saginaw, to name a few, have different providers, private vendors or homegrown systems that are providing service to their circuit court. So while we have the vast majority of the courts, we don't have the same majority of the cases. So as we continue to expand, using that money to migrate those systems onto ours, we will add resources and technical sophistication to JIS. Again, we have presentations for the appropriators on that coming in the next few weeks. So that's where we are. We're hoping to migrate all of those systems within the next 4 or 5 years, consistent with the appropriation boilerplate from last year.
Thank you, Judge. Representative Fink?
Thank you, and thanks for being here, Judge Boyd. It's interesting to be on this side of the microphone, having appeared in front of you a handful of times in the 55th District. So my question is in reflecting on the role that the court plays under our constitutional system, the separation of powers that I think each of us needs to take very seriously, and it's our duty to the citizens to guard the areas of policy or of government action that our branches are each responsible for. And I'm thinking maybe especially about a perspective like that of Alexander Hamilton in Federalist 78, which famously says that the judiciary has neither force nor will and even depends on other branches both to set the substantive law and to enforce the court's judgments. And so I'm thinking about, say the period of the pandemic and some of the court's actions regarding landlord-tenant cases, which again is the background that you and I share previous to this, and looking at it as it appearing that the court was making some substantive judgments about what outcomes ought to be. And so my question is, how does the court govern itself to make sure that it is not stepping outside the lane of essentially being the most passive branch because its job is to do justice under law, and rather than pursuing particular outcomes in particular kinds of cases?
Well, thanks for the question, Representative. While not Hamilton, I'll quote Bridget Mary McCormick in on the same vein, which is that the only thing the court system has is its own credibility. We don't have armies. We don't have jails. And the way we're going to get that credibility is to be as transparent as possible. And a lot of things you'll see that we're doing in many of the initiatives that I talked about yesterday and today are towards that transparency. I would politely disagree that what the court did during the pandemic had any hint of trying to pick winners and losers. During the pandemic in landlord-tenant cases, the court, through Administrative Order 2020-17, laid a framework to allow the programs that the executive and legislative branch had created to work. Not picking a winner or loser, but to be able to set the procedural posture, which is the Supreme Court's job, that those programs, so again, created by the executive branch, run through MISTA, and funded through the legislative branch, had an opportunity to work. So, for instance, what is colloquially referred to now as eviction diversion begins in Kalamazoo with Rich Santoni 15 years ago. We picked it up in Ingham County, I apologize, I don't remember for sure, 10 or 12 years ago. Certainly you experienced it when you were at the 55th. The point of eviction diversion isn't to pick a winner or a loser, it's to find a win-win solution. Because a landlord, as you know, filing for a non-payment case is specifically asking for payment as relief. And when there's a payer out there willing to pay, and the court can create a procedural posture for that plaintiff who's looking for payment, and the government entity or charitable entity who has the payment to meet together in court and to resolve amicably and everybody wins, I would argue, as 2020-17 implemented, that that's not picking winners and losers, that's giving the plaintiff what they wanted and assisting the defendant. Eviction diversion came to me in the district court from the Department of Health and Human Services. And when the director of the Ingham County Department of Health and Human Services, Ms. Sewell in Holbrook, came to me and said, come to Kalamazoo and see what they're doing there, I first watched eviction diversion. And I went back to her and I said, honestly, why do you care? What does this mean to the Department of Health and Human Services? She said, Ingham is second only to Wayne in per capita spending on homelessness. It's killing my budget. I need fewer people to be homeless. And by creating a procedural framework for people seeking money to meet people who have money, we dramatically decrease homelessness in Ingham County. So the goal isn't to pick winners and losers. The goal is to do our part to allow people to find win-win solutions.
Thank you, Judge, for that very thorough answer. We do have some cards submitted, which the clerk will put into the minutes. Due to time constraints, we cannot take any additional testimony. I encourage anybody that has submitted a card to reach out to my office or to my fellow members on the committee. We have no members absent, and there being no other further business before committee, the committee stands adjourned.